they did certify the shoreline. Different state agency, Department of Land and Natural Resources, the Department of Transportation then was able to identify what portions of the bypass road were actually in the setback. Had the survey found that nothing was in the setback, we would not be holding this hearing. Had they found earlier, through a current certified shoreline survey, that portions were in the setback, you council folks would be dealing with this as part of the resolution to approve or deny. However, because of the lack of a current certified shoreline survey is why the project now is going through phasing of the permit process. And with that, I will ask the state and its consultants to respond to the questions about the temporary bridge, its relationship to the temporary road, questions about the temporary road, and questions about the EA-EIS process.
What can you describe the temporary bypass road?
The EIS issue, anytime the Department of Transportation undertakes a project that requires review under Chapter 343, which is the EIS law, they start with a draft environmental assessment. That document was published, circulated for public comment, and as a result of that document, the input from the community was used to formulate the final environmental assessment. When the final EA was completed, it was evaluated and reviewed by DOT, who then published its finding of most significant impact, which is a requirement in order to publish it before the Office of Environmental Quality Control. So that documentation is on file with OEQC. Any additional copies you'd like to see of the EA can be accessed directly from their website.
Mr. Cole?
So the DOT is a self-certifying agency as to the adequacy of their EA, or
that is provided by law. That is correct.
That's very interesting.
Can I read something?
Yes.
This is the criteria for an EIS to be made, and it's A, in considering the significance of potential environmental effects, agencies shall consider the sum of effects on the quality of the environment and shall evaluate the overall and cumulative effects of an action. And I feel that their EA did not meet that criteria at all. They did not take into consideration the environment and what the effects of their project was going to do. This is law. This is a law.
Your input is welcome. Unfortunately, the comment challenge period on that EA has long passed. So.
And can I make another statement about that? These people here, the Department of Transportation and the representatives and engineers of RM Towel, sat in my yard at my picnic table and promised me they were going to do an EIS. They lied to me. They had already done an EA and they did not tell me about it. I don't know these things. I'm just a person living in a home trying to protect my property, my life, and my family's life. And they lied to me. They lied to my family. They lied to our neighbors.
We appreciate your perspective, and so, you know, we weren't there.
Yeah,
we have your comment for the record.
Okay.
We weren't there. Did you have a question?
Yeah, I just got a question about what you just said. Is it, I mean, because a lot of these people here that live around and near this project, were not given adequate notice about the original, when the draft EA came out. So is it possible to open it back up, to let the comments come in, and then close it up again and change the EA according to the comments?
The state law provides this process because the trigger was the use of state funds. The state DOT ran the project and the EA. Now, if it were a private project and not one of the triggers for state funds, and it was for a shoreline setback variance or a special management area use permit, then the Department of Planning and Permitting makes a call on the adequacy of the EA. But in this case, in terms of the hierarchy, they made the call, and that was allowed in state law. So we have no say in the timeline. Mr.
I
Cole?
have a question or a comment. And we had at the Resolution 11-282 a draft put forth by Tulsi Gabbard of PD1 in committee to add a 14-foot riprap embankment along our property and the front house and the lot behind us to protect us, because the other side is 12 feet riprap and the front house is 10 feet. So anyway, she introduced this. It was rescinded later because HDOT and Towel met with all the council people and convinced them to rescind it. I guess it's back as an FD1 now, or maybe not. Okay, anyway. But RM Towel submitted written testimony for the March 1st hearing at full council, stating that, you know, one reason they couldn't do any added riprap or anything added design changes like that it would require a new environmental assessment study and another public review period.
That is correct.
Is that correct, Brian? If you did any design changes?
We made two, if I may respond, we made two statements. That was one. And the other one was that it represented a spot improvement without benefit of proper drainage study.
May I add something onto that? Is that the $600,000 change order?
I don't know what that is referencing.
If there was a $600,000 change order, wouldn't that trigger a public hearing?
I do not know.
A change order, if the change order, you know, I don't manage contracts, but if the change order was simply because costs went up and didn't change the project, then there'll be no additional environmental assessment required.
We have the change order here.
But that's to the state, you know, that's
No,
their
this goes
project.
back to the EA, and if it's a valid EA. They did their EA months, years before they did this change order, and they changed the design. Wouldn't that warrant another EA or an EIS if they've changed it after the EA has been published?
At this point, we leave that to the lawyers. We're leaving that since the Supreme Court hearing.
Thank you for that clarification.
Then let me get this then. The question is that in the change order, or whether it's just because costs went up, is that what it was? Can we get an answer? Was the $600,000, at this table, can we find out, was the $600,000 because costs went up, or was $600,000 because there was a change in the scope of design? Oh, wait,
We have a
it's on the,
question
we have
already.
on the table.
We have a question. I have to, you know, defer to the state to answer that one.
We would have to go back and look into our project files and before we can answer that question.
Can you provide an answer to Councilmember Burke when you do find an answer?
Okay, so the question was,
The $600,000 change order.
Say it on the.
Councilmember, would you repeat the question?
I'm going to defer to
Back
Mr. Cole because he has the answer.
I